Today's tip comes from The Fearless Cross-Examiner, Win the Witness, Win the Case by Patrick Malone. And here with us today is Patrick to read the tip. Thanks for being here.
Glad to be here, Michael. The fact is, this is my tip, the fact is that all human beings reach judgments about what and whom they believe based on intuitive impressions that shortcut logic. Then, we often use the logical parts of our brains to justify and articulate the judgment we already reached using the inarticulate, my gut tells me part of the brain.
Wow, a very important concept. You can't just win trial by logic and thinking alone. Maybe you can, but I think trial at its highest art really gets to the gut like you're talking about. But maybe I'm reading this wrong. What do you mean by this?
No, I think you're exactly right. In terms of witnesses on the stand, this is something we all kind of know already, but it's important to keep in mind. You know, the best witness, if you're hiring an expert, is not the person who has the long resume. It's the person who can relate to the jury and teach them as a teacher and make them feel like they really understand the case. And the fact that they may not be the world's leading researcher on some arcane topic, it doesn't matter. What matters is the intuitive impression they create as a trustworthy person. Same goes for you as a lawyer. That's why you never want to look tricky or slippery or angry at trial. You want to be a good human being and appear as a good human being, someone the jury can trust. And then everything flows from that the logical stuff becomes much easier to persuade people with when you've already cleared the path by showing them that you're a good, calm, trustworthy person and that your witnesses are the same way.
In talking to great trial lawyers like yourself, it seems to always come back to this. It comes back to credibility and authenticity, and that everything else flows from that. But it's Aristotle's ethos, that is really most important, don't you think?
Yeah, and I love the Aristotle reference. He had a triangle, a three-part explanation for what is the art of rhetoric: ethos, pathos, and logos. Logos is the logical part. Ethos is you, the speaker, and pathos is the emotional appeal. All three of those work together seamlessly. There's never been a better explanation for persuasion than ethos, pathos, and logos.
You know, my memory of that was back from my philosophy days, was that he actually said that ethos should be the least of the reasons that people decide something, that ideally it would be logos. Like, I think this argument is coming back with, can you have an AI judge, which we can't quite get into that. But the reality is, whether it's fair or not, we know that's how people decide. That's the psychology of persuasion. The ethos really comes foremost for people. And I think that's what your tip gets to today.
Well, in terms of judges, that's why every single judge in the United States puts on a black robe before they go on the bench. It literally robes them in dignity and authority.
Oh, I like that. And then we call them Your Honor. We're an honor that comes with the robe and the position.
Yeah. Yeah.
Today's tip comes from The Fearless Cross-Examiner, Win the Witness, Win the Case by Patrick Malone. And Patrick Malone is here to read the tip today. Good morning, Patrick.
Good morning, Michael. Learning to keep your own emotions under control is even more important than learning to control the witness. The juror's perception that you are under better self-control than the witness is key to the impression you want to create.
This is something that I hear lawyers talk about all the time, losing control of their emotions and asking how to do a better job of that so that they're controlling their emotions. Emotions aren't controlling them. What advice would you give them, Patrick?
Well, it's something we could talk about for a real long time. One of the things that I always advocate for people is to try some distancing thing like meditation, even prayer, something like that to kind of pull you away from the moment. But the other thing I would say, just a very simple idea on the negative end, just bear in mind that if you find yourself in the middle of a heated moment at trial and you're losing control of your emotions, that means to an outsider that really you're losing this match, this little go round. And part of the reason for that is that jurors are very good human beings at judging other people's emotions. They can see it right in front of them. They're less good at judging the logical content that you're trying to put out there to them. So you don't want the emotions to interfere with the content. That's why it's better to kind of be neutral, maybe, be pointed, of course, and persistent, but, try to keep control. That's the best.
Yeah, and it seems like of all the emotions, anger is one that really gets to lawyers, and there's the fear, of course, if the lawyer's angry, that either they appear to be the bully or they take the righteous anger from the jury. What do you
Yeah,
think?
I mean, it's like if you're already, it's one of those things. If you smile, the world smiles with you. If you cry alone. Uh, but the the key thing about anger, on the one side, like you say, I mean, it's very easy to look like a bully. The jury is naturally more sympathetic to the witness anyway. They're kind of imagining themselves on the witness stand and confronting a lawyer who's got steam coming out of their ears, not a good thing to keep them on your side.
Today's tip comes from Winning Medical Malpractice Cases with the Rules of the Road technique. Patrick Malone wrote this with Rick Friedman, and Patrick Malone is here today. If you could please read the tip from your book.
I'd be happy to, Michael. The plaintiff's advocate must understand how the natural desire of juries to do good fits within the framework of a trial. The idea is not to instill fear, but to inspire courage. The strong plaintiff's verdicts come when the jury is empowered and ennobled to do good.
I absolutely love this tip. I think there's been such a focus on fear and people's fears, which is true. We want things to be safe and people, want a safe world. And I believe that all jurors, people want to do good in the world. They want hope as a theme. So how do we do that to show the jurors that, to empower them and ennoble them, as you write?
Yeah, I think that the idea is to point towards the better path, the path of uh, safety, preventing harm that's unnecessary to your fellow citizens. That's all uh, uh, about something that they can go home after the trial and be proud of having played a role in doing that. And there's countless examples of that in product liability, even, truck wreck cases, all kinds of things where the message from the jury is, no, this should not have happened. Here's the better way that we want people to pay attention to in the future.
Today's tip comes from Winning Medical Malpractice Cases with the Rules of the Road Technique, Patrick Malone with Rick Friedman. And here to read today's tip is Patrick Malone. Thanks for being here.
Thank you, Michael. Here's my tip. The advocate's praise for the American system of justice is an important piece of a good closing argument. The goal is to elevate the jury, to get them to see their function as not merely a fact finder between private disputants, but as the enforcer of public values. In a malpractice trial, where the two sides usually have very different social stations outside the courtroom, it's also important to stress their equality inside the court.
Wow, lots of wisdom here. I think of a couple of things. One is I think of all the different arguments really trying to get to what you've talked about, elevating the jury, whether it's noting their role as a hero, whether it's talking about, I've heard people say no one here is more important than you, not the President of the United States. You're the only ones that can decide the facts in this case. Elevating the jury. So why do we do that? And what are some of the ways specifically that our viewers can do that?
Well, one way that I often do it, we have a standard jury instruction in the District of Columbia. I think we also have it in Maryland, where I also often practice. And it just says all litigants are equal before the law. So the plaintiff is equal to the defendant, and nobody's better than anybody else because they wear nicer clothes or have more income or whatever the case may be. And I think that is a very noble concept. All persons are equal before the law. And, it's even on the frieze on top of the Supreme Court building, equal justice under law. So it gets to a very important concept, and it helps to diffuse the idea that defendants, who often have a much higher social status than the people we represent, that they're deserving of some kind of special deference. No, everybody's equal.
I love that. And I think it's important that we not only pay lip service, that we say that in our closings, but actually that lawyers feel and recognize that. I know some lawyers, I think, who will say those words, but their actions and sometimes condescending tones don't necessarily match that. So to me, part of elevating the jury is really recognizing their power in the system we have, and that on the whole, jurors do the right thing. We're not there to trick them. We have to trust them and elevate them.
Yeah. All that's good stuff. Another way I often do it, and this may get a little too fancy for some people, but I like to give some of the good quotes about the quotes from famous people about the jury trial system. One that I use is from the Frenchman Alexis de Tocqueville, who wrote the famous book Democracy in America, 150 some. Well, actually, it's been almost 200 years ago. And what he said was that the civil court system was an important educational locus of educating the public in civic duties in the United States. The other thing he said that was really important is that voting in a jury room on a case is equally as important as going into the polling booth and voting for who you want to be your political leaders. So there's a lot of meat there that I think lawyers are wise to try to get there. It also excites people's potentially their empathy towards your client The idea that we're all in this together, we're all citizens, you're doing a civic duty here. You're not just like arbitrators of a private dispute, but you're serving the public good. That's an ennobling concept that's important.
Today's tip comes from Fearless Cross-Examiner, Win the Witness, Win the Case by Patrick Malone. Patrick, thanks for being here with us today. Could you read the tip, please?
I will. Thank you, Michael. Every expert, and I put experts in quotes, every expert who climbs up on the witness stand is in fact an expert in some one thing, maybe in many things, but maybe not in what you think the case should be about. The expert may have a highly buffed curriculum vitae, but whether all his or her expensive expertise fits your case will never become clear to the jury unless you bring it out in cross-examination.
Wow, I think there's a lot here. One is the fancy CV, which might impress some people, but we know turns off some people. It might get less credibility because of it. And then also, you're talking about, and I'd love for you to explain this a little more, or give an specific example of they're an expert in something, but not what you need. So help us understand this, please.
Well, this is about the kind of qualifications piece of the expert's testimony. And a lot of people gloss over it. On cross-examination, it's very important because of the way cross-examination is structured. There's the voir dire stage of cross where before if it's an expert, before they get to put out any opinions about this case to the jury, you, as the cross-examiner, get to test that through some very pointed questions. So if you can take them down 2 or 3 notches, it's just a super powerful thing. One quick example. Let's say you're cross-examining a quote-unquote life care planner. It's a case with a bad injury, and you've had your life care planner testify, and now the defense has someone coming in. And let's say that this was a true story in my book. There was a cross-examination of a nurse life care planner who had all the credentials of all the little initials after her name that said that she was certified in life care planning. But had she ever walked the walk? She could talk the talk, but had she walked the walk? And it turned out that in her day job, she ran a Botox clinic and a clinic that did other kinds of cosmetic work for people. Did she ever actually work with paralyzed people like the guy who was the plaintiff in this case? No, never. She would come up with these care plans, but strictly for lawsuit purposes. So that's somebody who, yeah, they were credentialed, but they didn't really fit the case because they had never really walked the walk. And that's something I think it's very important to pay attention to.
I think that's a great example. And, in my question, I was thinking more of direct exam. But as I'm thinking about it, as you're talking about cross-examining, which your book's about, it actually helps us on direct, right? If we think through what the cross of our expert's going to be, so we might be able to attack the other witness for that. We also want to make sure that our expert doesn't fall into that category where they're not walking the walk.
Exactly, right. Yeah, you don't want to be the pot calling the kettle black. But it brings out the importance of practical experience, practical relevance to what's important in the case.
Today's tip comes from The Fearless Cross-Examiner, Win the Witness, Win the Case by Patrick Malone. Patrick is here with us today. Could you read this morning's tip, please?
I'd be happy to. Witnesses are like everybody else. They are looking out for number one with every question you ask.
But can you tell us more about that? What do you mean by that, Patrick?
Well, it's one of those things it's both self-evident, but it's also kind of a subtle point. Um, Everybody wants to look good on the witness stand. They know they're on a stage. They're trying to perform. They want to look good for their own ego, and so getting them to admit they've made a mistake is something that's going to cause attention and discombobulation, and sometimes they'll to avoid that. Like if you've caught them in a mistake, for them to avoid admitting it, sometimes they'll evade your question because they don't want to admit they've done something wrong. So the whole idea of this is to kind of think while you're doing the cross-examination of reversing the situation and how would I handle it if I was this witness? If you realize that the witness is always looking out for themselves and they'd rather be evasive than answer a simple question, that way you can be prepared for it and come back at them in a little more empathetic way, really, but one that will ultimately get your point across much more effectively. So think about the witness as looking out for themselves and how you can kind of channel that and empathize with it to make for better cross-examination.
I love the idea of reversing roles with the witness to see and feel where they're coming from. Sometimes when I do that, I think about ways to reduce their resistance to what you're saying. So, for example, it might be a police officer who has entrenched themselves in a position. And I might say something like, now you could only work with the data you had, right? And the data you had admittedly wasn't complete. Giving the witness an out it seems to me one way to do that in an empathetic way that doesn't embarrass them. Because when you say looking out for yourselves, people have a fear of public speaking. They certainly don't want to be embarrassed on the witness stand.
Yeah, exactly. Right there, Michael. The idea of giving them some graceful exit path that preserves their own ego. And in the meantime, they may have to give up the case that they're trying to advocate for, but one that preserves their position, their dignity, can be very important.
It's funny you say that because, for probably most witnesses, their dignity might be more important than the outcome of the case. It probably is.
Yeah, I think so.
Today's tip comes from the classic Rules of the Road, a plaintiff's lawyer's guide to proving liability. Here to read the tip is Patrick Malone, one of the Rules of the Road authors. Good morning, Patrick.
Good morning, Michael. Here's the quote. We believe plaintiffs' attorneys need to spend a lot of time in discovery and at trial, painting in the backdrop for their rules so that by the time the jury is deliberating, they not only know the reasons behind the rules, the jurors, but they become invested in the case as safety guardians for the community.
Wow. First, I've got to say this book really is classic. If you don't have Rules of the Road, you need to go out and get it. What you and Rick Friedman did in writing this, all of us owe you a real debt because we're talking about the standards of care. We're talking about the rules in the case and a way to present those. You've helped us find a way to present those in a way that the jury can access. So I'm curious if you can just talk to us a little bit more about that, what you mean by that, and how we use these rules.
Well, the word rule, it's a simple four-letter word, but it can sound very arbitrary. I mean, there are rules against double parking in the street, but when you couple a rule with safety, something that preserves the community, and becomes a safety rule, then it becomes important, and it becomes something that people are on the jury and everywhere are invested in as something that is important for preserving the safety of the community. The other thing about knowing the reasons behind the rules is um, it's just a simple question, the best of the 5 questions, the who, what, when, where, why, how. The best one is why. Why do we have this rule? If it's a good rule, it's one that the other side has to agree with. And that makes them squirm, but it makes for a much more powerful case.
Wow. So develop the rules, make sure that you give the why for the rules, and that really should be simple and make common sense, right?
Exactly.
Today's tip comes from Winning Medical Malpractice Cases with the Rules of the Road Technique by Patrick Malone with Rick Friedman. Here to read the tip today is Patrick Malone. Thanks for being here, Patrick.
Good to be here. Here's the tip. As you near the end of your outline of topics for an important expert's direct examination, look for a place to end strong, even if some minor point may be left unsaid. This is Persuasion 101. Start strong, end strong.
Great advice today. Start strong, end strong. It sounds so simple, and I think it's ignored so often. Start strong, end strong on your case, on your day with your witness. And you said something else here, which is so hard for lawyers. You might have something that you want to say, but if it's not super important, and you can end strong, skip it. That's hard to do.
Exactly. Yeah, and it's also true for cross examination. You're trying to create an impression uh, of strength for your case, and not that you're there to just be a little bean counter and tallying up all the little tiny points of disagreement with the person you're cross examining. So the idea, it's primacy and recency is another way of putting it. Start strong, end strong.
Today's tip comes from Rules of the Road, a plaintiff lawyer's guide to proving liability by Rick Friedman and Patrick Malone. Here to read the tip is Patrick Malone.
Good morning. Show the jurors you care about your case by showing them you cared enough to do the work, to be meticulously prepared, and to back up everything you tell them. You must trust them to understand and have the appropriate emotions. You don't have to tell them how to feel or what to think.
Trust the jury, and you don't have to tell them what to think. That might go counter to what some lawyers believe. Can you talk more about that?
Well, it's just the idea of being a trusted guide to people where you're not hammering them over the head all the time. I mean, you can repeat stuff, yes, important themes, but you don't have to, beat people over the head with it. One of the things, being prepared, backing up everything you tell them, that just shows that you're competent and that you're trustworthy. And then once you've made yourself competent and trustworthy, then trusting them is just a natural part of the bonding process, I think.
It seems to so often always really come back to credibility, create the credibility, and from there, it's then easier to make the arguments.
Yeah, yeah,
Yeah.
very
And,
true.
and to not, it's very interesting to not tell the jury how to feel or what to think. Um, I'm really glad that you wrote that. Any final thoughts on that?
Well, it's a little more subtle than some people want to be, but I think it shows more respect for human beings in the jury box that you trust them to do the right thing, and you don't start shouting at them and browbeating them and stuff like that.
Some great wisdom this morning. Thank you for sharing it, Patrick.
Thank you for having me.